So, what does it actually take to commit a crime? Well, it's way more than just having a guilty thought. Today, we're going to break down the first essential piece of the puzzle, the Actus Reus, which is just the fancy Latin term for the physical guilty act.
But first, let me throw a question at you. Can you be found guilty of a crime for doing absolutely nothing? Seriously? Picture this. You see someone in terrible danger. You could easily help them, but you just don't. You walk away. Have you actually broken the law? Stick around because the answer is probably not what you think.
All right, here's our roadmap for today. We'll start with the basic building blocks of a crime. Then we'll get into the super important voluntary act rule. From there, we hit the big twist, when doing nothing is a crime. And we'll look at the 5 key situations where you legally have to act. And finally, we'll wrap it all up and see why this idea of a guilty act is so fundamental. Okay, first things first, let's look at the basic anatomy of a crime. Because before we can understand the wild exceptions, we gotta get a handle on the rules.
You know, to actually convict someone of most crimes, prosecutors have to prove that 2 key things were present. Think of it like a recipe. If you're missing one of the main ingredients, you don't have a crime. And here they are. First, you've got the Actus Reus, the guilty act. This is the physical component, the actual doing of the thing. Then you need the mens rea, the guilty mind. That's the mental side of things. For the rest of this explainer, we're going to zero in on that first piece of the puzzle, the physical act itself.
Now here's the thing. It's not enough for a physical act to just happen. That act has to be voluntary. And this brings us to a really critical idea in criminal law, the voluntary act rule.
This is the bottom line. The law only punishes you for actions you choose to make. If you don't have conscious control over what your body is doing, you haven't committed the guilty act. It's really as simple as that.
That sounds pretty straightforward, right? But what the law considers an involuntary act is actually a very narrow category. So what does it really mean to lose control of your actions in a way that the law recognizes?
Well, the law is pretty specific here. For instance, if a tennis player slips on the court and their racket flies out of their hand and hits their partner, that's not seen as a voluntary act. Or what if someone physically grabs your hand and forces you to pull a trigger? Also not voluntary. The same goes for things like a knee-jerk reflex, or something you do while you have a concussion, or even while under hypnosis. In all these cases, your mind isn't in the driver's seat.
And we got one of the clearest definitions from the famous case of Brady. Lord Denning put it perfectly. He said an involuntary act is something done by the muscles without any control by the mind. Just think of a spasm, a reflex, or a convulsion. In those moments, there's a disconnect between your brain and your body.
Okay, so a crime needs a voluntary act. We've got that down. But this brings us right back to that question I asked at the beginning, and to the really shocking exception to this whole rule.
This quote might be hard to swallow, but it's a classic principle of common law. The jurist J.F. Stephen laid it out way back in 1883. If you see a stranger drowning and you could easily save them by just holding out your hand, but you choose to do nothing, you have committed no crime. The law, generally speaking, doesn't force you to be a good Samaritan.
Unless, and this is the big one, unless you have a legal duty to act. This is the pivot point where everything changes, because in certain very specific situations, the law says you must step in. And if you don't, your failure to act, your omission, becomes the guilty act.
So what are these special situations? Let's dive in to the 5 main duties to act. These are the exceptions where doing nothing at all can land you in some very serious legal trouble.
So the law carves out these specific circumstances where this duty to act is created. This duty can spring from a specific law, a close relationship, your job, or even from a dangerous mess that you accidentally created yourself. Let's look at a couple of key examples.
All right, 2 of the most common duties pop up in our personal and professional lives. First, there's the duty from a special relationship, like a parent has to their child. And second, there's a duty that can be created by a contract you've signed. A couple old cases show this perfectly. In Gibbons and Proctor, a father and his partner were actually convicted of murder because they failed to feed his child. The court said their relationship created that duty. Then there's Pitwood, about a railway gatekeeper whose job, his contract, was to close a gate to keep people safe. He forgot, someone died in a crash, and his failure to do his job was enough for a manslaughter conviction.
Okay, now for a really interesting one. The duty you get when you accidentally create a dangerous situation. The case of Miller is the perfect story for this. So you have a guy who accidentally sets his mattress on fire with a cigarette. He wakes up, sees the flames, but instead of trying to put it out or call for help, he just gets up and moves to another room and goes back to sleep. The whole house catches fire. The court said, look, the moment he became aware of the danger he created, he had a duty to take reasonable steps to deal with it. His failure to do so was the guilty act of arson.
So, when you put it all together, why does the law focus so intensely on this physical guilty act? What does it really tell us about where we draw the line between law, morality, and just plain responsibility? Well, by focusing only on whether an act was conscious, the law takes this very technical, almost surgical approach. It intentionally separates the physical action, the how, from the much messier, more complicated question of why the person did it. Your motives, your background, your reasons. The law basically says those things are for figuring out the sentence later, not for deciding if the act itself was fundamentally guilty.
All right, let's wrap this up with the key takeaways. Number 1, a crime needs a voluntary physical act. You can't be punished for your thoughts alone. Number 2, involuntary acts, reflexes, spasms don't count. And finally, while you generally can't be punished for failing to help, there's that huge but: you absolutely can be found guilty if you have a special duty to act, whether it's from a relationship, a contract, or a danger you created.
And all of this leaves us with a really tough question. The law draws some pretty clear lines, but are they the right lines? As a society, where do we think our legal duty to help a total stranger should begin and end? It's one of those fascinating points where law and morality don't always see eye to eye.